cards and to find out what the personal identification number is. And it's interesting that one thing that the bank does, and all of you should go back and read your account opening documents, is that you have to choose numbers that are not easily discoverable by another person or third party. So you can't combine birth dates of your children, for example. You can't use your own birth date. It has to be a number that, again, is not readily available to the world. And I think with the elderly, often they will use a number that is known to them, their birth date, or something that's familiar, an address if it's a 4-digit. So things to keep in mind as well. And then obviously the bank, I'm going a little bit off topic, but a bank will look at that as well to try to limit liability if you choose a PIN number that is the same as your birth date or another number that's easily found out. Forged checks is another good example of what can happen as is being added as a joint account holder. Often the elderly need help with banking, so someone is invited to sign on board in good faith, and for many years it's fine, but then things can begin to deteriorate after time. As I said, I'm going to focus on bank accounts because I think that's something that's easily available to the fraudster. So what is then the responsibility of the bank to monitor, report, and stop these kind of frauds? And conversely, what is the responsibility of customer, elderly or not, to really monitor their accounts and to report on these frauds or irregular transactions that may take place? Most account opening documents require a verification agreement to be signed, and that's really the crux of what we're talking about in this whole field and what the bank will rely on and which a customer will try to distance themselves from. A verification agreement is simply that. You have 30 days, it's usually 30 days, it can be a bit longer, but 30 days to report any irregularities in your transactions to the bank. It has to be in writing, and it is, again, 30 days usually after the receipt of either your account statement sent by mail or if you have a passbook when your passbook is updated. Now, some people say, well, I don't update my passbook that often, and that may be true for the elderly, though the elderly seem to, not surprisingly, do it regularly, but you have a requirement to update your passbook as well. So you have these account opening documents that can be quite complicated. The language can be quite arcane, as I said, about the access card and choosing the right PIN number, but also the verification agreement about what your responsibilities are as a customer. It's a contract, so it can be enforced in the ordinary course by the bank if there is an action. It's probably fair to say that the bank has an obligation to explain a verification agreement to its customers, depending on the sophistication. If it's an elderly customer, most likely they will have to go through the language so that the customer can understand what they face. And the same is true if a verification agreement, I would argue, was signed several years ago, which can often happen. You open a variety of accounts with the bank, and over time, the elderly person forgets what the verification agreement is all about. So the bank may have a duty to revisit that to some extent in order to explain a verification agreement. So there may be an ability to limit liability from the bank on that point of view as well. When a joint account holder is added, usually documents are signed. Often it's just a signature card, which I think the bank can get into some trouble with, because I think you have to go back and look at that verification agreement as well so that people understand that those are the terms that you're signing on to. Now, the Supreme Court of Canada has said that in absence of verification agreement, there is no duty for a customer to report irregularities to the bank. There is no duty to monitor or report within a reasonable time. And there's a famous case, Canadian Pacific Hotels, which I won't go into, but essentially the Bank of Montreal, and my apologies to any bankers in the audience from that institution, were nevertheless found liable because they did not, they tried to blame the customer for not verifying the accounts, and the Supreme Court of Canada said no. So the upshot is verification agreements are now standard. Very few accounts are opened without them, and if they're not, it's just pure luck, and that's just a happy circumstance for any litigator who's trying to challenge that or anybody looking into that. The Supreme Court of Canada also said it didn't really matter the level of sophistication that the customer had. In this case, it was Canadian Pacific. which had internal controls and accountants, but nevertheless, there was no duty to report irregularities. So again, you're faced with signing a verification agreement in most instances now because of that case. So always the first question would be in an elder fraud with the bank, is there a verification agreement? And if the answer is yes, was it adequately explained to the elderly? Was the elder person in a position to understand the terms of it? Was it revisited at all? So all these kind of common sense questions would come to the fore. Another issue is, was the bank familiar or aware of any physical or mental impairments? So for example, if someone was blind or became legally blind, and as we know, you can still see, you may not carry a white cane, but you'd be declared legally blind for other purposes, driving, for example. So if the elderly person would come in and routinely update their passbook, I think you could argue a teller might have to explain to the elderly what the transactions were in the passbook, because the teller came to realize that the person was legally blind, for example. So the bank would have to make, I think, reasonable accommodations to the extent that it knew of any physical or mental impairments. Now, of course, as soon as you throw the word reasonable out in front of lawyers, there's a variety of different responses to that. Much depends on the fact, which is another great thing lawyers love to say. It's all fact-driven, and that's largely the case. And so what's reasonable, what are the facts of the case, is really going to determine, to some extent, whether the bank has some liability. Liability such that it can't rely on the verification agreement, because what the elderly customer would do would try to distance themselves from the verification agreement, argue that it was void from the very beginning because it wasn't explained to them properly, or that because reasonable accommodations weren't made, the verification agreement should not be enforced against them. So those are things that would happen, I think, during the course of it. Now, if the bank is made aware of irregularities after the 30-day period, of course the bank will rely on the verification agreement. Say it was conclusively settled that the transactions that had appeared in your account, either through a passbook account or account statements, were fine because you didn't complain. The bank would also say it's too onerous on us, for example, to go to every customer and say, do you understand your verification agreement? Or we understand that you now have a cane, or you're physically impaired, or has something changed in your circumstances, or you're now coming to the bank with Betty. What's that all about? So obviously the bank is going to say, and to some extent rightfully so, there's only so much we can do. So again, we're back to what are the reasonable accommodations a bank can make. And indeed, another question, a broad question that is placed in front of the courts when it comes to banks is, what is the bank's duty to investigate? Does the bank, as a reasonable banker, have a duty to investigate these kind of fraud transactions? Now, it's in the bank's interest, obviously, to investigate these transactions. Why? Because a customer still can report in that 30-day period that there are irregularities, and if the bank is able to stop them, then the bank obviously limits its damage internally for someone emptying an account, for example. But again, if it's after the 30-day period, they would take another tax. So it's in the bank's interest to investigate. But if the 30-day period has come and gone, can someone still come back to say to the bank, well, yes, you have the verification agreement, but what about your duty to investigate as a banker? Aren't you supposed to behave as a reasonable banker in the circumstances and protect my interests? And most of the cases say that the bank does have a duty to investigate. There are very few cases that I could find where the tension between a verification agreement and a duty to investigate was really looked at. But nevertheless, we all know, for example, Visa can be very active in monitoring transactions on its account. So it seems to imply if Visa is so proactive, because probably we've all been in a position where our cards are terminated, or we get a call because there's unusual transactions taking place on our account. So if Visa is so quick, why can't a bank do something similar to alert the elderly or a trusted advisor of the elderly that something's up? So again, most banks, I think, I understand, do have anti-fraud policies and provisions in place to try to catch these things. So that would go, I think, to some extent to say, well, the bank has these provisions in place, these policies in place. There was a duty to investigate. They didn't. So there should be some contributory negligence on the part of the bank if I didn't report in time under the verification agreement. So you can see that tension there that comes up. Sometimes the courts, too, have applied what's called the principle of two innocents. It's really an equitable principle in the end. In other words, the court is struggling to find a fair outcome based on the facts in front of it. And that's where two parties suffer, and I'm just reading from the case here, due to the fraud of a third party. The party who most contributed to creating a situation conducive to the fraud will bear the loss. So there you could argue that who's at fault? Who didn't do what they were supposed to in trying to monitor this fraud? And for example, the bank can argue that the elderly person should have had proper controls in place, a continuing power of attorney, bringing in a trusted family member or a trusted advisor. Now the irony of that is that's the very person who can ultimately take advantage of the situation. But nevertheless, the bank can say, there's only so much we can reasonably do. This is what is expected of us. This is what we knew or didn't know, and therefore we took the appropriate steps. Again, just to conclude, much depends on the facts, as I said before. Is the fraud notorious? Was it ongoing? Was it repetitive? Many of these frauds, for example, I was involved with one case where it looked like the caregiver gained access to an ATM card, and they went to obscure ATM sites. They went to the convenience stores. So if you're a fraudster in the audience, this isn't a bad way to do it, because convenience stores have the standalone ATMs, which is by some private company not associated with the bank. No cameras. No cameras. So that's easy to do, because if you're in the bank, of course, you can wave to your mother all the time and it would come up in a video. But in a convenience store, that's not the case. You can also move around the city fairly easily to the convenience stores and find convenience stores that are out of the place. So there's no pattern, but the pattern that does appear is you see the transactions of $400 a day. They always tend to go to the limits. You know, they try to take out as much as they can. So you can, because the idea from a fraudster's point of view, not that I'm a fraudster, is but you want to empty out as much as you can before your day of glory comes to an end and you're caught. So there's some facts that may drive the case. So if it's notorious, it's something that they should be able to pick up. And the other one, of course, is time. If it goes over a long period of time and that the accounts begin to drop down, it can't. It's something that can probably help someone's case. So in the end, I think in terms of recommendations, for those from the bank, I think it should be remembered. The bank should remember that frontline tellers and other personnel should keep their eyes open and be aware of things that are happening if there are suspicious circumstances. And it's always nice to know your customers. They say that they probably should act on that and at least make some investigation if, as I said, there were suspicious circumstances. From the elderly person's point of view, I think they should have in place, as best as they can, certain procedures to protect themselves. If you're the lawyer or a family member, obviously approaching the bank and saying, my mother or my father or my client is now elderly, there's been a joint account being put in place or a power of attorney being signed, please be aware that such and such is the case, and you need to keep an eye on this a little bit more than you would, and that would obviously help your liability in the end. So thank you for listening, and have a good morning.
Thanks very much, Justin. And now we'll ask David Smith to speak about support claims by a non-married spouse.
Thank you, Susanna. The title of my paper, I use the term non-married as opposed to common law for the simple reason that it doesn't create confusion. All too often we will have prospective clients or persons contact us and say, I'm the common law spouse. And of course we all know that common law has a different meaning, for example, under the Income Tax Act than it does under other legislation. In our practice then, and what the focus of this paper is is if there's a support claim being asserted by someone who says that they're a spouse of the deceased, but not a married spouse, what's particular about those claims? What do we have to do as litigation lawyers to advance the argument that our client meets the definition of spouse under Part 5 of the Succession Law Reform Act and is accordingly entitled to some quantum of support? And so in my paper I set it out that we've got basically 4 general areas of inquiry. The first is cohabitation. We have to meet the requirement under the statute, which is Part 5 of the Succession Law Reform Act, that our client, who in this scenario is cut out of the will, has a legitimate claim against the estate. The second area that I'm going to cover is how do we prove that relationship? Of course, for us as litigation lawyers, again, everything is just been pointed out is fact-driven. So we need to adduce evidence to support our client's position. And I'm going to touch on the fact that we need corroboration of that evidence under Section 13 of the Evidence Act because it's an estate proceeding. The next issue I'll touch on is the competing claims and how we deal with those. That is competing claims by other defendants, particularly in light of the Cummings case, which I'm not going to speak on in great detail because that's been touched on in many previous presentations. But I will touch on how that impacts the non-married spouse and how he or she will best argue that that the deceased owed them some kind of moral obligation. And the last point I'll touch on very briefly is alternative strategies. The starting point for any support claim is Section 58 of the Succession Law Reform Act. And that section simply provides that where a testator did not properly provide for a dependent, then that dependent can seek relief from the court, and the court may order such proper support as it considers adequate out of the estate. And so 2 words jump out. Support has to be what would have been proper support, what would have been adequate support. In Cummings and in other cases, the court employs the test of the judicious father or spouse in terms of determining what would be a fair allocation of the estate, having regard to all of the competing claims of the dependents. Now, the specific concern of a non-married spouse turns on the wording of Section 57 of the Act. And that section simply says that a person with whom the deceased was cohabiting continuously for a period of not less than 3 years is a spouse for the purpose of the Act. So the concern that we would have is how do we establish in front of the judge that our client was continuously cohabiting for a period of not less than 3 years. The term cohabit has typically been found to mean living together in a conjugal relationship. The problem that we have with this area of the law and the arguments, and the reason there's so much case law on this point, is that, again, you have a question, you have to determine what's proper support, what's adequate support. We then have to say, well, what does it mean to cohabit with someone? What does it mean to be in a conjugal relationship? And so there's been a great deal of attention given to the various factors that determine cohabitation. There was a case called Thovet and Malion, a 1996 case of the Ontario Court General Division, as it then was. And that employed a test that's been followed in many cases since then, which basically looks at various headings that I set out in my paper. And this portion of my paper employs the exact objective criteria, if you will, to determine if non-married spouses are cohabiting. The court will then, having consideration to each of the headings, evaluate the case on its merits, having regard to the specific facts, which again must be corroborated by some other material evidence. It's not enough for the non-married spouse to simply say, I was looking after the deceased, I was treating the deceased as a husband or wife. There's got to be some corroboration by other material evidence. So, for instance, the first heading is shelter. Did the parties live under the same roof? What were the sleeping arrangements? Again, if it's a single bedroom dwelling, one bed, and there's not going to be much issue about that. Of course, the reality is that more often than not, you'll have a multiple bedroom dwelling. There will be circumstances which actually give rise to whether or not they were sharing the same bed. The court will not typically get bogged down on that as the sole determining factor, but the court will try and get a picture of the relationship as a whole to determine, does this relationship look like a spousal relationship? If we step back and look at it globally, on balance of probabilities, were these people spouses? Did they cohabit? And that's really the key word for getting through the first threshold, which is establishing that you are in the class of persons who can make a support claim. An interesting case in February of this year. It's not referred to in my paper. The site is Glenn v. Kirk McLean Estate. And I'll just give you the site. It's an unreported case. Ontario Judgment Number 520 if you're on Quick Law or Estates Partnership. The interesting thing about this case is with respect to the question of a conjugal relationship. In this case, a homosexual female made a claim against the estate of a homosexual male. And the question was, well, can these two persons be in a conjugal relationship? And the judge in that case determined that no, they can't be. There were other factors as well. But the court said that more often than not, a case will not turn on the question of whether or not there were sexual relations between the support claimant and the deceased. However, in this case, the court said this can't be a conjugal relationship. I think it's an interesting question as to whether a different judge would come to the same conclusion, particularly in today's political climate. So, interesting case there on that specific issue. With respect to the other criteria that the court looks at, the court will look at the services that were rendered, for lack of a better term, by the support claimant to the deceased. In the case of either a female or male support claimant, the court will say, well, what did this person do for the other person, which was in the manner of a spousal relationship? Did they prepare meals? Did they do the laundry? This sort of thing. And so that's the kind of criteria that the court will consider. In our experience, quite often, this is the most difficult area to corroborate in terms of proving whether the non-married spouse in fact did the work for the deceased that he or she said that she did. The difficulty with corroboration is there may not be any witness to the relationship at that kind of intimate level. And so the issue of corroboration does come to the fore. Typically we can corroborate the relationship through, commonly we will have Christmas cards, birthday cards, things of that nature. Any kind of paper evidence that documents the nature of the relationship. And so again, in the paper we touch on that. Of course, the common tendency is to think that a support claimant must have been financially dependent and in need of support in order to assert a support claim. That would seem self-evident. In fact, especially in light of the Cummings decision that I will touch on, the court will consider a lot more than simply need in determining whether or not support should be paid. In the case of Reed Davies that I touch on page 7 of my paper, the court noticed that the word support does not just mean financial support, but it can be extended to include physical or moral support or other support by what some may, of another nature, that others may consider to be non-essential. It will all depend on the nature of the relationship. Quite often in the non-married context, you'll have a situation where both the deceased and the support claimant were in previous marriages, and for whatever reason those marriages ended. They will not then enter into a second marriage together, and they will in fact maintain separate residences. Is that fact fatal to the support claim? Again, the answer is it will depend on the facts of the case. I refer to a case called McKeckern and Fry Estate, the 1993 case of the Ontario Court General Division, as it then was. And in that case, the court said, even though there were separate residences, even though there were no joint bank accounts, even though the people owned separate vehicles and did not live together at all times, and did not refer to each other as husband and wife, nonetheless, this was a spousal relationship for the purposes of Part 5 of the Succession Law Reform Act. So the important point, I think, the message I want to convey is a spousal relationship, from my review of the case, will be quite liberally construed, having regard to more than what would traditionally have thought to have been the case. And the fundamental point I want to convey, and which comes through from an analysis of Cummings and the application of Cummings, is that need is not the sole determining factor in evaluating a support claim. A non-married spouse who has sufficient means of her own may still assert a meaningful support claim. The issue will go to whether or not the quantum of support should be significant having regard to their own needs and all of the other factors that are considered by the court and by the statute. In my paper, I also touch on a case called Craddock and Glover Estate. Another interesting case. The reason I've referred to this case is that the deceased left a note with his secretary in which he stated a clear intention to leave the support claim in $100,000 in a life insurance policy. As it turned out, he did not have a life insurance policy in that amount of money. This document was not considered to be a holograph will. The court found that the evidence, being the note, corroborated the support claimant's position that the deceased intended to benefit the support claimant. That is, that the deceased had an intention to treat the dependent as a dependent. And so the court said, well, look, that corroborates your position, support claimant, that you're a spouse, that the deceased had an intention to benefit you, but for whatever reason was not manifested in the last will. So I think we've covered the issue of cohabitation. I want to turn now to the situation, which is if you've proven that you're a spouse, so you're a non-married spouse, the court is satisfied, or the other side admits that you're a spouse, how do we determine the appropriate quantum of support? On page 9 of my paper, I point out that under the Family Law Act, at section 30, it's enshrined in statute that all spouses have an obligation to support one another. And the definition of spouse under the Family Law Act is the same as the definition under Part 5 of the Succession Law Reform Act. The point being, and this is my view, the point being that once you establish that you're a spouse, even if you're not married, it's going to be quite easy to then say there was a legal obligation to support me for no other reason than I'm a spouse. The Family Law Act provides that authority. The spouses have an obligation to support one another. In my view, that is a position that is an appropriate transition into a support claim under a state law. And in fact, in Craddock and Glover, the presiding judge agreed with that submission. The other benefit of being a spouse is that, again, the requirement is that there's a legal obligation to provide support immediately before death. The argument would be that if these persons were spouses, then they remain spouses right up until the death. Therefore, that legal obligation continued. Certainly, competing arguments could be made that there's an obligation to demonstrate that support was actually provided by way of payments or what have you right up until the date of death. However, it's not practical in many cases. For instance, in cases where the deceased dies after a lengthy hospital illness, clearly during that period of hospitalization, he or she would not have been providing any financial support. In my submission, if I were in front of a judge, I would say, look, that's still the spousal relationship. The hospitalization does not negate the fact that the support claimant for however many years was receiving support and was a dependent of the deceased. Cummings very briefly, in addition to what I said earlier. The significance of Cummings was that it said, okay, you've got to consider moral obligations that the police have when evaluating support claims. Cummings is particularly relevant when you've got more than one support claimant, because there the court has to weigh competing support claims, say, okay, if I'm in the deceased's shoes, who am I going to provide for and in what amount, and to whom do I owe a moral obligation? The nice question is, does the fact that a non-married spouse is not married, does that in any way reduce the moral entitlement? Is it a different moral entitlement that would exist if the spouses were married as opposed to not being married? These are issues that the court really needs to explore in some more detail, and I expect that's where we're going to see the evolution of the case law. There was a case earlier in 2006, Pirelli and Coley estate. Again, unreported, the reference is OJ number 465. This case was one in which the non-married support claimant was admitted by everyone to be a spouse, so she didn't have to prove that she was in need of support, she didn't have to prove that she was a spouse. On the issue of quantum, she was the only person the court had to consider. But in that case, Justice Henderson said if there were more than one claim, you would have to, as I noted earlier, weigh all of these claims, have in consideration to moral obligations, and make a determination as to whether or not the common law spouse is entitled to a quantum support. This comes to the fore most frequently when you will be acting, for instance, for a non-married spouse, making a support claim, and you'll be in competition with ex-wives or ex-husbands, as the case may be, who have in hand an order saying that they're entitled to support. There's a legal obligation to provide them with support, or alimony, if you will. Their case is more of a slam dunk because it's a court order, it's crystallized, it's liquidated as to the amount that they're to receive. It's more challenging acting for the non-married spouse to satisfy the court as to the quantum that you're entitled to. I've already touched, I think, on corroboration, the most difficult element of a support claim. Very briefly, cohabitation agreements between a support claimant and the deceased will not necessarily be fatal to the support claim. It's one factor the court will consider, but if someone is clearly in need and the court is satisfied that there is a moral obligation, notwithstanding a cohabitation agreement, the court may say that this is nonetheless a case where support is appropriate. Very last point I just want to touch on is what do you do if you don't meet the 3-year continuous cohabitation requirement? Is there any remedy that you can assert? In the case of say yes, there is. Constructive trust is one angle that you can take. Another argument would be a concept which we're trying to advance in some cases on behalf of clients in these kinds of situations, which is the concept of proprietary estoppel. It's a subject for another paper, but in essence, it's detrimental reliance upon representations where the deceased promises someone that he will look after a person, will marry that person, and that person, being the support claimant, relies on that promise, does not meet the 3-year period. The alternative argument would be to seek relief under the equitable remedies available. Those conclude my points. Hope it's been helpful.
Thanks very much, David. And now for our last speaker, Ian Hull. Ian's going to be speaking about spousal trusts.
Good morning. Well, I want to just touch on the concept of spousal trusts, and I sort of have 3 points I want to try to make in my time. The first is really relating to the concept that Oscar Wilde, it's a great quote from Oscar Wilde. He says, it's better to have a permanent income than to be fascinating. And coming from him, I thought that was pretty cool. But I'm sort of struggling with this topic because it seems to me to be a really interesting planning tool and one that can be used effectively when we're dealing with the family dynamics and tax dynamics and economic considerations but it's not being used as effectively as I think it should be and can be. We certainly see lots of wills with spousal trusts in them, and I've got sort of I'll go through a little bit about some of my comments about the general concept of the spousal trust and then the twist that has been around for a long time, but I think isn't being used as much as it could be. But to start off, it seems to me the idea, if you're going to impose a spousal trust for the good reasons that may exist in your client's situation, the first thing that we do, where we trip up on, is that we don't really explain to our clients, and in my theory is to the family, just what we're trying to get at. It's not just about avoiding taxes on death and things like that instantly. And the communication of the concept of spousal trust is something that I think a good reporting letter has to be supported with it when we put it into the mesh and some meaningful communication. And there's a great book written by a guy named Nick Renton, and I'm blogging books, but it's called Family Trusts, A Plain English Guide for Australian Families of Average Means. Now, the fact that it's Australian there's just some parts of the tax stuff you can glance over, but he's an actuary, which seems even more bizarre that an actuary, but he does a great job in describing in plain English some of these concepts that I'll often just sort of summarize, and it really does hit to the core of some of the simple and the complex aspects of family trusts and why we're going to be using them. He talks about advantages and disadvantages. He talks about the different types of trusts. He talks about how family trusts deal with them, like just the basic tax concepts, and then how it dovetails with with estate planning and with charitable considerations. So anyway, if you're interested in that book, just send me an email and I can tell you how somehow we got that off the Australian publishing world. But I just thought it was a good illustration because if you go to the leading texts for the Leon Trust and so on, and you try to create some sort of explanation that the client or family members are going to understand, it can be awkward and facetious in time. So we've got the idea of a family trust. We've got the concept that it can be creatively used. The basic principles, of course, that we've got this trust, we've got this settlor there with money or property, handing it to a trustee and creating this legal and beneficial interest, and all of these rights that get created in that context. And the two things that I think are missing when we go to explain to our clients what we're doing here and why we think it's got great tax advantages or whatever family dynamic advantages it has, the two things are what are the rights when the trust is created? And secondly, what are the fiduciary obligations? Because we have now turned this money or property into this, handed it over into this world of fiduciary obligations. And again, those are the things that we see every day, people tripping up on, that they're not recognizing the rights that get created, and we're not recognizing that the people that are involved in the trust environment who are actually administering this trust often don't understand the fiduciary context. So what I will often do is I'll sit down and go through varieties of trusts and options. Obviously, the spousal trust I want to talk about today, but there's lots of options. There's tremendous amount of flexibility. Discretionary trusts, inter vivos trusts that do different things, restrictive trusts, asset protection trusts, income trusts, lots of interesting estate planning options. But when I'm creating any of these trusts, I always keep in mind, that sort of the context is that we've got to have these three certainties established. We have to have certainty of the beneficiaries, we have to have certainty of the property that's being given in the trust, and certainty of the intention to create the trust. So what is the spousal trust? And for our purposes, Section 70, sub 6 of the Income Tax Act allows for a rollover of assets from one spouse to another spouse, common law spouse, qualifying spouse, common law partner trust, all sorts of definitions that only the Income Tax Act can expand us into. But if we are spousal in nature and it rolls over, there's no capital gains that's paid. So there's also the aspect of that there's no recapture triggered, and that's important when you have, depending on your assets, of course, circumstances where the issue of recapture can be a big number and something that is also a great tax deferral. So the tax deferral is the obvious reason why we want to consider these trusts and why we want to sort of move into that type of planning. Under Section 70, sub 6, though, it goes on to say, all right, if you're going to do this, though, there's some pretty strict rules that you have to follow. The deceased must be resident in Canada. You must be transferring as a consequence of death, so you must die, which is a great expectation. You can apply the rollover with or without a will. And there's also some creative aspects with dependent relief claims that David talked about today. We have to be careful about how we might be able to, if we do have a dependent, and if there is or there isn't a spousal trust created, is there an opportunity even to save some immediate deemed disposition tax in a dependent environment? So the succession planning aspect of a trust as a planning vehicle gives us the tax deferral, gives us the protection of family assets. We can, in some cases, leave assets more or less in place to allow for sort of organized transition and management of businesses and so forth. We are obviously worried most about the deemed disposition and the treatment of capital gains, but we're also, it gives you some flexibility to deal with income tax over time and how it will be taxed, the income will be taxed. So the obvious advantages of testator may own shares and the cost base is, say, $10,000, and the date of death they're worth $100,000. Normally, of course, we've got a deemed disposition, fair market value, capital gain on that is $90,000. So those who inherit the shares are deemed to have acquired them at $100,000. And at that point, of course, that creates what is the family dynamic or the tax dynamic that can be overwhelming. Sometimes you simply have to sell assets unnecessarily to sustain or to pay for the tax. So the motivations at that point in time can be really skewed. As I say, I'm not going to get into too much detail, but there's a whole bunch of recapture reasons as well. When we get into a situation where we've got real property and we've depreciated it over years, we've got a cost that has been broken down over years with great recapture issues, and then on the date of death, we can also use the spousal trust to give us some relief on that and hopefully preserve assets for the short term. So the other point I just wanted to make was, so we have the spousal trust concept, and we have to be careful that we arrange it tightly within the confines of the criteria under the Income Tax Act. And the key is that no other person other than the spouse can obtain the use of the capital and the income. And the terms, what we call, have to be clean. They can't be tainted. You're going to lose your rollover right if the testator creates a trust that provides for anyone else benefiting it. So the spousal trust, for example, that allows for debts to be paid and taxes to be paid out of it, can be seen as tainted, and someone other than the spouse is enjoying the benefit of it, and Revenue Canada or CRA is all over us. There are some special provisions under Section 70, Sub 7 that the personal representative can untaint the trust, and we can create some magic in that regard. But one of the drafting notes that I've always thought, and I don't see as many of these when they come across our desk in the litigated environment, that I always thought was a good creative tool. It's sort of been described originally as the Wolf Goodman type of trust, where you set up two trusts in the will. You draft up, you allow the executors to split the assets into two trusts, a spousal trust and then into a non-spousal trust. And this drafting technique, it seems to me, gives so much flexibility to the family at the date of death and allows you to identify what assets need to go in the spousal trust and what should go in the non-spousal to fund the moment in time, because it is so difficult to predict just what is going to be there at the date of death. And this type of, it can get more complicated in the drafting standpoint, but this type of option really seems to me to resonate well, and I've seen it used in many cases very effectively, where we've got a situation where we might have assets or shares that are, just full of capital gains, and we can throw those in the spousal trust. Hopefully, they're producing a little bit of income, and then the assets that aren't quite as full of capital gains, we can put in the non-spousal trust to help fund, which are inevitably ongoing expenses. We really, as I say, see the mechanics of this not as often as we can. The Ray Nichols case, which is in my paper, was a Court of Appeal decision that left this option where the trustees can decide how much. But really, essentially, what they're saying is that the trustees have some flexibility at the date of death. But I've unfortunately been involved in some of these where they're not properly drafted, so I will say, from that standpoint, that we have to be very careful about how we will arrange those trusts. So I think really, from my standpoint, the practice notes are threefold. One is that if we're going to do these things, they have such tremendous value, both from economically and from a family dynamic standpoint, to organize the family affairs and the resources of the family at death. That we want to, A, consider the trust, the spousal trust, communicate what the spousal trust, the terms are, and how we're going to impart them to the family. To the client, but in my view, the extended family is also a consideration. To let people know what they're going to get themselves into, especially the surviving spouse, and to make sure the surviving spouse understands the nature and extent of what kind of lifestyle they're going to have if this arrangement is created. And then thirdly is just to sit down and try to address the spousal trust in a more creative way in the right circumstances. And as I say, the Wolff-Goodman split is just one suggestion, but it's one that really just highlights the fact that at the end of the day, if we don't get creative with our clients and we don't offer these sort of suggestions, then I think they can be missing out in opportunities. So, as I said, I recommend if you want to, I can happily give you the details of that book, and we have a few minutes, as we like to do, at the end now, just for some questions. So thanks very much.
So do we have any questions at all this time? Yes.
One for David. David, are there any cases where cohabitation agreement that they allow as a household plan? It seems to be very effective in your remarks about the way you...
Just need a microphone. The question, yes, yeah. The question was in my talk. I said that cohabitation agreements are not fatal to all support claims. Are there cases? The cases tend to be family law cases. In the family law bar, the validity of separation agreements, marriage contracts, that sort of thing, have gone right up to the Supreme Court of Canada. And so certainly there is a body of case law which can be referred to in the estate litigation context, going to the whole issue as to whether or not those contracts will exist. To the extent that there's cases in the estate litigation context, I'm quite certain there are. I don't have any reference in my paper. I can try and make some cites for those. But certainly, where there is a cohabitation agreement, the court will look at the contract and all of the principles of contract law. If there was independent legal advice and all of the essentials of the contract, I think it's fair to say it's going to be tough to set aside that agreement. But again, the authority, if you will, is in the statute, which says that the existence of an agreement is just one factor for the court to consider. So I would actually argue that you refer to the statute in addition to any case law.
Yes,
I actually have a question for Ian. On page 3 of this paper, you've indicated that you could avoid paying probate fees and also creditors if you create the trust through the will. And I'm just not clear on that because I always assume that you pay probate as at the date of death value. And I'm not sure whether the estate is actually transferring the assets to the spousal trust.
I think I was referring more to the testamentary, the inter vivos context.
Oh, okay, thanks.
On that, yeah. Sorry, it was just on the probate fee issue of spousal trust. One option to help avoid that horrible probate tax that we live and breathe to avoid is to consider the context of creating of an inter vivos environment. So that was what I was getting at. Any other questions, thoughts? We've got callers. I don't think they can call. We're not there yet. We're hoping to be there. We'll be setting up. We're going to be moving into hopefully some webcasting and moving this platform to new heights. But we're not there yet. We're not there.
just following up on that now, we're pleased that we've got a new website that's up and running, same location, but a new look to it. And one of the things that we're able to offer now is our previous breakfasts. Some of our previous breakfasts are actually on our web now, so you can watch them. I mean, the quality is not at its highest, but they certainly are there for anyone who's interested. And at some point, hopefully this breakfast will get on there as well. So if there's no more questions, I'd like to thank you all for joining us here today and look forward to seeing you again in the future. In the interest of getting this started and ended on time, I'm just going to ask our speakers to please come to the front. Now. Welcome to everyone who's joined us here today at our Fall 2006 Cullen Hall Breakfast Series. We're very excited to have three very interesting topics to present to you today. And I thought before I do that, let us just introduce the members of our crew who are here with us today. We've got Rodney Hull, who's just taking a seat in the back there. We've got Ian Hull.